Hi, my name is Bill Brush, and I'm the president and founder of Cut Unnecessary Regulatory Burden. We're going to be speaking about the changing history of project regulation here at Smith Mountain Lake from approximately 1960 to present. I'm going to try to connect those dots for us. Well, back in the 30s and right up into the early 60s, APCO was purchasing land or condemning lands and paying for condemnation, and negotiating flowage easement right deeds with property owners. The purpose of the easement was to allow them to construct, to maintain, and to operate dams and power stations, and to impound the waters. On Smith Mountain Lake, they could flood up to the 800-foot contour, and at Leesville Lake up to the 620-foot contour. And those water levels would vary as they generated power and operated the project. Well, those flowage right deeds benefited both parties. APCO was granted the right to enter and clear anything in the project boundary that would interfere with the construction, the operation, and the maintenance of the project, while the landowner retained all rights to use that easement for any purpose so long as he didn't interfere with APCO's flowage rights. And that included the right to reach the impounded waters for recreational purposes. These rights were deeded, and they flow with the land, and they're held in perpetuity. On April 1st, 1960, the Federal Power Commission issued Appalachian a 50-year license. The license contained no requirements to regulate the private use of the shoreline, or to permit docks, boat ramps, or beaches, or to permit shoreline stabilization, and even dredging wasn't mentioned in these licenses. In 1967, and again in 2004, APCO delivered detailed project drawings. The purpose of the drawings was to show where the project was located and where the project boundary existed. All lands that composed the project were shown by subdivision, and specific flowage rights were shown for each parcel in the project. This is the notes and reservations page of the original drawing package for the project. As you can see, the notes are extensive, and they cover and speak to every parcel that composes the project and what rights those parcels had in terms of flowage. We're going to come back and review this again a little later on in the presentation, but the purpose of showing you this page is to show that Appalachian initially disclosed accurate ownership and rights within the project back in 1967, and again when they submitted these drawings in 2004. Let's review a little bit more about the history of regulation that came to impact us. First of all, back in 1970, that's when the Environmental Protection Agency was formed. 7 years later, the Federal Energy Regulatory Commission replaced the old Federal Power Commission. And in 1980, FERC ordered the first time a standard land use article for the Brazos River project. And what this did was tell that licensee that he had authority to permit routine non-project uses within the project boundary without going to the FERC and asking permission. Now, 1986 comes along and the Federal Power Act gets modified with the Electric Consumers Protection Act. It was supposed to provide more protection to electric consumers, but in reality, this shows the emergence of concepts of economic justice and social justice. Because this is what the Act was all about. It required FERC to give equal consideration to the purposes of energy conservation, the protection, mitigation, and damage to fish and wildlife, and to protect recreational opportunities and preserve other aspects of environmental quality. Now we come to February of 1998 and the start of our troubles at Smith Mountain Lake. That's when FERC amended APCO's license to add Article 41. This was the requirement to start regulating uses within the project boundary. Those uses consist of what you can read on this slide. It gave a very broad extent to this. At the bottom, just read, to protect and enhance the project's scenic, recreational, and other environmental values. Now we're at 2003, and that's when APCO published its first shoreline management plan. It began to require shoreline property owners to apply for revocable permits for their docks, for their vegetation removal and addition, for shoreline stabilization, for dredging. They issued specific requirements and size limitations on docks. And they even went so far as to classify shorelines. I call that zoning. They call it classifying shorelines. Shorelines were divided into shoreline that could host commercial, public, and residential development of either high or low density. They even identified certain shorelines as impact minimization or conservation environmental. Conservation environmental meant wetlands. Impact minimization meant something that required protection, but they weren't quite sure as to what that protection required. Then in July of 2005, FERC issued the order to implement the Shoreline Management Plan. When it first did it, it prohibited dredging, riprapping, and construction in the project for 4 out of 12 months. The community had to fight that, finally got it changed, and the only thing that's prevented for 4 months out of the year is dredging during spawning seasons. But that should have given us a hint right then and there that the FERC knows better on how to regulate and operate this project than we who built it and who own the property along it. I put the badge up there to show this is where FERC literally gave Appalachian the power of legislator. They could write the rules. The sheriff, they could police the rules. They could judge whether or not you were compliant with the rules. They would be the jury to decide if you were guilty, and any appeals would have to go through them and to the FERC. Well, it's a kangaroo justice process. Both AEP and the FERC are in cahoots here. If AEP denies something, the FERC will back them up, and vice versa. During this period of time, one of our prominent attorneys here at the lake, George Vogel II, questioned the right of Appalachian to require permits. He basically said that lakefront owners had vested property rights and that this permitting process were taking those rights away. FERC responded to that and simply said any questions concerning property rights will have to be resolved in a property law action in a court of appropriate jurisdiction. A nice way of saying take Appalachian to court and sue them in state court. Well, we're back to drawings again, and this time in March of 2008, APCO submitted a complete new set of project drawings. And the notes on this drawing basically consisted of 2 notes. I'll read the number 1 note to you. Licensee has obtained all flowage rights necessary for adequate operation of the project. Well, that's not a true statement. You remember the extensive note pages on the drawings that were submitted in 1967 and again in 2004. Well, nothing changed. No flowage easement agreements were changed or nothing changed, but Appalachian simply just brushed that aside with this first note. Interestingly enough, these Exhibit G drawings don't meet their license requirements because they're supposed to completely and accurately disclose its property interest in the project. And they're supposed to do that by parcel. They're supposed to show which parcels they own in fee simple, which parcels are owned by someone else, and which parcels only have flowage easements on them. And these drawings don't do that. Let me show you that on the next slide. Here is the 2008 project drawing of the Blackwater and the Roanoke River Junction. Here is the Water's Edge subdivision, Smith Mountain, and here is Smith Mountain Lake Dam and the raceway into Leesville Lake. Now that you're oriented on this drawing, look closely. You'll see no information about parcel. You'll see no information about ownership. You'll see no notes of any substance on here. And this is the type of drawing that was submitted, which contrasts quite significantly from the next drawing I'm about to show you. Well, here, let's look at the original 1967 project drawing for the same area. This is the Water's Edge subdivision right here. Okay, so that you're oriented. And you'll notice that on this drawing, number 1, there's extensive notes, and those notes correlate to parcel information throughout this drawing, even for parcels under the water. It details the ownership of those parcels and what flowage rights exist for those parcels. Completely detailed, completely compliant with license requirements, unlike the set of drawings that Appalachian submitted in 2008. Well, even though they didn't submit compliant drawings, FERC nevertheless gave them a 30-year license. As a part of that license, Standard License Article 5 requires Appalachian to acquire title or the right to use in perpetuity all the lands necessary for appropriate operation and maintenance of the project. Well, you can see that the one note they wrote that said, hey, we've got it, trust us, we hold those rights, that wasn't shown on any drawing or in this certification. We believe this certification to be false and misleading. Now comes January 30th, 2014. FERC issues a new order modifying and improving an updated shoreline management plan. But even here, the issue of property rights continued to raise its head. Several individuals had questioned whether or not a dock was a right or a privilege, and the Commission said they explained that way back in 2005, and they were getting a little tired of hearing about this apparently if you read the last sentence. It says, if an individual's deed gives them that right, they should take it up in court. Well, that's supposed to be state court, and what FERC has really said is, we do not want to hear any more about this. We've heard enough. If you have a problem, it's a problem between you and the power company, and you go ahead and take that $16.5 billion corporate monopoly to court and defeat their property rights interests if you feel you have this right. Well, it seems clear to me that FERC is complicit in the taking of our property rights. They've gradually increased regulation at the project at the expense of our rights. The commissioners have told us they don't want to hear about this any longer. They don't want to see any more comments. They want to speak to any more comments. So they've tilted the scales of justice against us. Virginia is a property rights state, and property rights rule in this country and in Virginia. But FERC's ignored that and allowed Appalachian to submit a drawing package that fails to meet their requirements and a certification that says, trust us, we have the property rights necessary to adequately regulate the project. Well, as you can see, from 1960, when this project was first formed with a handshake and an agreement with property owners that we could use the project for recreational purposes, now we have to sign those rights away with an APCO permit. This isn't right, it's not correct, and the purpose of this whole presentation was to show you how gradual this process was and how increasing regulation stole property rights from us. What can we do to save our property rights? Let me suggest sending a financial contribution to C.U.R.B. C.U.R.B is a 501c4 corporation registered in Virginia as a not-for-profit. Our mission is to educate and inform citizens of the importance of property rights so that we understand what we can do to protect them. So, in order to save your property rights, I suggest sending a substantial donation to C.U.R.B. Thank you for taking the time to view this presentation, and hopefully you have an appreciation for how important property rights are and how gradually those rights are being taken away from us with increasing FERC regulations.